I have two brothers, and they were homeschooled, and they were taught that they could do anything, regardless of how big it was. And so we decided to do some music, and that belief, and I would attribute it to them, led to over 30 national television shows. The Tonight Show with Johnny Carson, and Christmas in Washington with President Reagan, a bunch of stuff like that. So a few years ago, my brother got this passion for studying law, and he got involved in representing himself in state and federal court, suing banks. And that sounds a little crazy, but he did it on his own, and he was able to prevail in some instances, and he was able to actually take a couple of cases all the way to the U.S. Supreme Court. So he was successful in actually getting it to them. Just formatting a petition for writ of certiorari is very expensive, extremely difficult, and he was able to do that twice. So he had this experience.
To get into this whole lawsuit in this case, how did this?
You mean from the very beginning, getting into the Constitution, or getting into the lawsuits?
Well, maybe your inspiration for the Constitution first that led to this, right?
Guilt.
Oh, guilt.
I felt guilty for not reading the Constitution after I saw Barack Obama, tell the world that it was fundamentally flawed. So I looked at the presidential oath, and it's like, you know what it is, preserve, protect, defend, uphold the Constitution. But when you see it in the Constitution, it's a whole different world. I don't know why. But, so the three of us, with our different interests, were able to combine into a pretty good union. Three brothers being able to actually launch two federal lawsuits, knowing that one of them was going to get to the Supreme Court first. And that was our premise. We knew that the U.S. attorneys were going to come on and toss it, right? So many people bring lawsuits, and they say, oh, it got tossed. It's like, no, it got dismissed, and now you have to appeal it. And then you keep going until you get to the Supreme Court. And that's where the win is. And that's where we are with this case, at least.
Mm-hmm. So when he was watching the congressional hearings of this 2020 election, he just came unglued. He couldn't believe that even though Josh Hawley and Ted Cruz and about 98 others wanted to have a simple 10-day investigation, and the other members of Congress wouldn't do it, Mike Pence wouldn't support it either, that he thought something has to be done. So he got thinking, it's like, gosh, we should, I should file a lawsuit. So he got with me and so he decided to, I volunteered to be the plaintiff. He wondered if I'd be the plaintiff. So we filed a federal lawsuit in the federal court of Utah. And we went through a lot of hassles, blockage, all kinds of crazy stuff there to try to even get mine served. So, but eventually mine was served, and served by the U.S. Marshal Service. So Nancy Pelosi, Adam Schiff, and about 80 others were served my summons and complaint by the U.S. Marshal Service. And it was no charge to us, because at the time they had locked down and surrounded themselves with, a great big wall or whatever. So because of that, that was able to happen for no charge. So, but then the judge canceled it out. It was March 31st, 2021, I believe. Canceled it out, and like an apology, said it was a mistake of the court, and said that my complaint was deficient. So that started a lawsuit against the federal court and the 10th Circuit Court of Appeals. That's a whole nother story. So meanwhile, my other brother, decided it'd be better to have two cases going at once. And our goal was to get to the U.S. Supreme Court. We knew that the U.S. attorneys would, file motions to dismiss, and of course the courts would uphold that. And so he went into state court with it, and then he got it into federal court, and they made a decision to dismiss it. So we got to the 10th Circuit Court of Appeals thinking, hey, go ahead and dismiss it as fast as you can so we can go to the U.S. Supreme Court with this. Well, they didn't dismiss it. They just sat on it for like 4 months. So we got together and thought, we have to do something here. They could sit on this forever. And so they sit on it for like 3 or 4 months, and we get together and go, well, now that's the same thing that's happening in an identical case. I launched mine first. Roland, my brother, we all decided that it'd be a good idea to launch 2 federal cases against the defendants, so that one of them would go to the Supreme Court and get there before the other. And this was the plan at the get-go. It wasn't about the lower courts. We just wanted them to go ahead and do their dismissal stuff, get it dismissed so we could go up the ladder, up the chain, so we could go right straight to the Supreme Court after it was completely adjudicated in the lower courts. So here we are with my brother Rollins. I'm stuck in federal court, and there's a big story about that because we actually took the federal court and the 10th Circuit Court to state court and sued him, and after that they released mine and issued 388 summonses, which started being served to all the defendants and were eventually worse. So here we are with the 10th Circuit Court of Appeals sitting on that to the Supreme Court. So my brother and I put some pressure on my legal-minded brother, who's behind the legal procedures and everything, said, you've got to find some rule, some civil procedure that we could bypass the 10th Circuit Court decision because we're just, they're not doing anything. So he did some research and he called me and he was excited. He says, the Supreme Court has Rule 11 that allows you to bypass the final 10th Circuit Court or a circuit court without their decision, but it has to be deemed a national emergency. So he says, what we have to do is when we file this petition, it's got to actually say on the cover, petition for the United States Supreme Court, petition for writ of certiorari under this court's Rule 11. So we put it all together, and the Supreme Court requires especially bound, and you have to go through some pretty good formatting to get it to them correctly. So we had it perfect bound, and we sent it off to them, and just with our fingers crossed and prayers that they would accept this as a national emergency and let us bypass the 10th Circuit Court of Appeals decision since they were sitting on it. So 5 days later, my brother, the plaintiff, received a phone call from the clerk's office. Now, the clerk of the Supreme Court is not just a justice clerk. The clerk of the Supreme Court is, I believe his name is Scott Sessions Harris. And for 11 years, he was the attorney for the Supreme Court. And so a case analyst from his office calls my brother and told him that they had decided to accept this case based on the Rule 11 petition platform, which means they were accepting it without us going to the 10th Circuit Court of Appeals because they obviously characterized this as a national emergency. And so they also requested that he put additional pleadings in it that they had been seen in the docket from the lower federal court. And so they said, put that in there and then get it to us as soon as you can. And so we put that all together. And 2 days before we were ready to get it off to them, the 10th Circuit Court of Appeals, we were notified, had made a decision. And so it's like, well, now we don't need the Rule 11. So we thought, well, should we just leave that information in there or take it out? So he called the Supreme Court, the number that they gave him, and talked to the case analyst. And she says, now that they've done that, you don't need the Rule 11 part of it. Just take that out, take it off the cover, and put the stuff in we asked, and then get it to us as soon as you can. They said, how soon could you get it to us? And we said, well, my brother said, well, about 2 weeks. And they said, well, can you try to get it to us sooner than that? So a week later, they had received it. So what happened is we got it to them. We mailed it on the 20th of October. They received it the 21st, and they docketed it on the 24th, and they showed that it was filed on the 20th, the day we sent it. That's standard procedure. And then they notified the U.S. attorneys who were defending the 388 defendants that they had until the 23rd of November to respond with an opposition. That was their deadline. They get one chance. They can file an opposition to this petition. That's it. As soon as they file that, it goes to conference where the 9 justices hear this in a private room, and they take a vote on it, whether it moves forward to a full-blown hearing with the litigants, both parties represented, go ahead and argue before the justices or not. So we send it off to them, and they accept it, and then they notify the attorneys that they've got till the 23rd. So the 23rd rolls around. That was the day before Thanksgiving. That was Wednesday. So Wednesday, we're thinking their deadline is up. Why hasn't anything happened? What's going on? The U.S. attorney's dropping the ball. What's going on? They're going to miss their opportunity to oppose this, and that'd be fine with us to miss the deadline. So all of a sudden, like early afternoon, we see on the docket that the U.S. attorneys are no longer representing the 380 defendants. They have been relieved of their duties, and now the United States Solicitor General is representing as their legal counsel the 388 defendants on the complaint. And she also signed a waiver waiving their right to fight against it, oppose it. It's called a waiver of waiving their right to file an opposition. they waived their right to oppose this petition before conference. So it goes, and now it goes into conference. So now it goes into conference without an opposition from the defense attorney.
Is that do you have some thought as why they might have done that? I would think that they would have
fought that with every tooth and nail, right?
Well, I think that there's a lot of ways you can you can kind of feel that happened. We feel it was like it was divine intervention.
That's what we're thinking, literally. Yeah.
Maybe the Solicitor General could see that this was a powerful and a constitutional and patriotic petition. This petition gives the Supreme Court more power than they've ever been given at a critical time when they're being threatened, the country's being threatened. We're facing so many things, a possible third world war, nuclear holocaust, all kinds of crazy stuff. So maybe she felt like this was just the thing to do. But then also the Supreme Court clerk had asked us to put stuff in there that would be like an opposition. We put their motion to dismiss, which would be like an opposition. But for her to not ask for an extension and for her not to put more materials together for a final fight against this petition was just amazing. In my book, she became a hero. She asked us to include in the petition the U.S. Attorney's motion to dismiss. So we put that in there. So they will be able to look at every single item that the U.S. attorneys have used to defend their 388 defendants in the full case. Okay, so they will have that. Now, they also, like I said, gave the U.S. attorneys an opportunity to add more to it, and they waived that right. So they only have the motion to dismiss, which is completely only about immunity. They never got into the merits of the case, ever. As a matter of fact, we had 2 cases going, and my case I was actually able to use to create a full summary judgment motion because they basically admitted wrongdoing in my brother's case that is now in front of the Supreme Court. But they only defended this the position, like I said, only based on immunity. And in a way, I think, if I remember right, that they actually conceded and admitted to some wrongdoing, but they just claimed immunity. So what the Supreme Court justices are going to do, I don't know, but this suit challenges the immunity they've given themselves. Article 6 of the Constitution requires that all of them be bound, all of our representatives be bound by oath. And we're, in our pleadings, we state in the complaints, we show that they cannot be bound by oath. They have to be bound by oath. They can't give themselves immunity and not amend the Constitution, basically. So them giving themselves immunity is a violation of Article 6 of the Constitution that requires they be bound by oath. You can't have immunity and bound by oath. They contradict each other. So there's an immunity question here, as well as the breach of national security that they were all guilty of. I hope that's helpful. I'll try to.
Yeah, it is actually. But the thing is that now this is just a sort of philosophical idea.
Sure.
Is it possible that they don't want to go into the merits of the case and that they never intend to go into the merits of the case? Because at that point, they would have to consider that there was the possibility of fraud in the election. And you just said, there's this thing about fraud is, all deciding, right? If there's one fraud, it's everyone's.
Well, it's not about fraud. It's not about fraud. It's about investigating whether there was or not. That's what it's about. It's not about fraud at all. It's about investigation.
All right, but they still have to, the merits of the case are not about immunity, except as they're looking at it. They're only saying whether or not they're immune.
They know they didn't investigate crimes that we had 100 witnesses. We had 100 creditable witnesses that said, hey, this needs to be investigated, and they refused to do it. Well, right. Guess what? Guess what we saw on the docket today?
It's going to conference?
It's been distributed to the justices for conference scheduled January 6, 2023.
Oh my gosh. Okay,
you're the first one to know that, well, on an interview.
Breaking news.
They shouldn't call it a hearing. They shouldn't call a trial a hearing. So the technical term for hearing is when both the attorneys representing both sides get in there and they argue in front of the justices, right?
Yep.
Okay, that they should call that a trial, okay? Because the conference scheduled for January 6th for this case, all 9 justices appear at the conference. They go into the conference. They've studied the case since right now till January 6th. They've studied the petition, I'll call it. And so they take a vote. No one else is in there. Attorneys for either side are not there. No litigants. Just the justices are in there in conference. They talk about it, they discuss it, and they take a vote. And so they vote on whether it moves forward to a full-blown trial. I'll call it a trial, okay? But
Okay.
attorneys can call it a hearing. That would be that big hearing, right? And so if 4 of the 9 justices vote in conference to move this forward, then there will be a full trial where, hearing in front of the justices where they decide on whether or not to grant the reliefs and do everything that the complaint asks the court to do.
Wow. Okay. So we're going to talk about what the complaint asks the court to do. But if they just say they don't want to hear it, the politics all gets involved and whatever, then it just goes away. Is that correct?
Yeah, if they decide in conference that they don't want to take it to trial, we'll call it trial, or to a hearing, then we file a motion for reconsideration. And we also have another federal lawsuit that's identical to this that we can take to the Supreme Court. And then meanwhile, people that are watching this show and other media outlets rally around together, show their support as a great United States of America to the justices so that they, with a motion for reconsideration or this other case, they can make the right decision. But we think they're going to make the right decision on this one based on how anxious they were to get it and what it's about, because it's not about the outcome of the election. It's about voter integrity. This would put to rest anyone from either side complaining about, election deniers. Is that what they call us, right? Or call everyone? Everyone's on both sides.
Anybody
Everyone's an
who
election
questions
denier.
it is an election
Well,
denier.
this would put that to rest, because then the election deniers wouldn't be able to say, you wouldn't even investigate these claims. It's like, well, that's why, and one of the reasons they need to be investigated. Another reason is that there's a national security issue that is linked to some of this fraud and crime, that they could discover a huge iceberg under this little tip of ice that 100 witnesses, credible witnesses, wanted to have explored and discovered. Let's go down and see if there's an iceberg under this little piece of ice. But we need to do it. And so because they didn't do it, they breached their duties. They breached national security. They broke their oath of office. And it's a form of treason, in my opinion, because it's a national security issue. It's not about who won and who didn't win. So they failed to do that. And so the complaint asks the court to remove every single defendant from their federal position and bar them from holding public office on any level in the United States for the rest of their lives.
Okay, so we're going to talk about what the complaint asks the court to do. But if they just say they don't want to hear it, the politics all gets involved and whatever, then it just goes away. Is that correct?
Yeah, if they decide in conference that they don't want to take it to trial, we'll call it trial, or to a hearing, then we file a motion for reconsideration. And we also have another federal lawsuit that's identical to this that we can take to the Supreme Court. And then meanwhile, people that are watching this show and other media outlets rally around together, show their support as a great United States of America to the justices so that they, with a motion for reconsideration or this other case, they can make the right decision. But we think they're going to make the right decision on this one based on how anxious they were to get it and what it's about, because it's not about the outcome of the election. It's about voter integrity. This would put to rest anyone from either side complaining about, election deniers. Is that what they call us, right? Or call everyone? Everyone's on both sides.
Anybody who
Everyone's an election
questions it is an election
Well,
denier.
this would put that to rest, because then the election deniers wouldn't be able to say, you wouldn't even investigate these claims. It's like, well.
Now to raise a joyous sound, 4 brothers whose silver trumpets took them from their home state of Utah to Hollywood, and tonight to Washington, D.C. Here are the Brunson brothers.
All right, I want to talk again about the Supreme Court case. Any one of you who did not see Friday's show, and a lot of you did, because 276,000 as of this morning have already seen that show since Friday. 276,000 different people have watched this. Mono Salmon was on. He told the whole story of how the Brunson brothers ended up bringing a court case before the Supreme Court. They have it in the courthouse, as I understand it, but they will meet on January 6th, which is obviously a prophetic, historic date based on what happened on the last January 6th of 2021. And it's going to be a epic court case if they accept it. And when I say epic, I mean it's going to overturn everything. And I mean, you talk about this being overturned or that being overturned. This overturns like everything. And so we're asking you, first of all, watch that video. But second of all, we're going to supply to you a letter to send to the Supreme Court. I have my own copy here. I'm going to sign it here. I'll do a fresh printout. I'll sign it here. It's got the address up here. Let me read this to you. She'll put that on the screen, but we're also going to show you a link. See the link at the bottom? It says ElijahStreams.com//court. You type that in your browser and another tab even while you're watching this, and up will come a fresh copy of that letter. Print it out from your printer. Print out several copies, give it to your family and friends. And this is what the letter says it's got the 9 Chief Justice and the other 8 Associate Justices. And it says, "Dear Justices, this letter is to express my support of the above referenced case, Brunson versus Adams. I am concerned that the United States has experienced a national security breach and a violation of every citizen's greatest power in a republic, voting. I ask that you stand against the adherence of foreign and domestic enemies and uphold the supreme law of the land by granting this petition. You truly are in a position that represents a court system greater than the world has ever seen. I, along with many others, seem to be witnessing our nation captured, and I am left to wonder if it might be by some of these very respondents. I pray for the right and just outcome, and I am grateful for your time and consideration. Sincerely," and I'll just sign Steve Schultz, and I'll put the date. So you don't even have to put your address. You can put it on the outside of the envelope if you want. People have said, well, can't I just email it? Well, you can, but it doesn't carry nearly the weight of someone stopping, printing out a letter, signing it, putting it in the mail, putting a real stamp on it. That's where the weight. But you only have about 3 weeks, 4 weeks maybe 3 weeks to mail it within that time frame to get to them before January 6th. So they will be counting these, of course, and telling the justices how many people have sent this in. So please, please, please do that. So there's the link there, and they will be putting that link in the in Rumble underneath the comments. And I think there could be a couple places they put those. They might put it in the chat as well. So go to that. We'll leave that up there for a few minutes under my picture here. And so you don't miss that. Be sure to write. Be sure to do. I'm going to do it today. I'm going to get it in an envelope, put a stamp on it, and get it in the mail so that my vote is.